it raises questions about whether or not he's being treated differently than other individuals in a similar situation. If you look at Mr. Keck, he filed a claim stating that he was a victim of domestic violence, and the prosecution says we're not going to prosecute.
Good morning, Judge Monty Palazian, appearing on behalf of Ms. Campbell.
Morning, counsel. I do see Ms. Campbell is with us. Ms. Brucker is here from the prosecutor's office. This is the date and time set for sentencing. I have received, looks like, so is the victim, Ms. Brucker's victim named Adam Howe?
Yes, Your Honor.
All right, I have received the victim impact statement. Give me just a second to review it, make sure I remember what's in it. All right, I've read that statement. There was originally a plea, looks like back on April 24th to domestic violence under the delay of sentence statute MCL 769.4A, and today's date was set for sentencing. And I agreed to consider dropping the no contact order after I read the victim impact statement. So having said all of that, is there any other documentation I need to be reviewing?
I do not have any, Judge.
Counsel?
I don't believe so, Judge. I think it says it right there. The only thing I would add to that is, you know, my client is 5'1". He weighs 107 pounds. Adam is 6'4" and weighs 240. I don't think there's going to be any issues. I don't think there's any fear there. Obviously, from the letter that he wrote, it's very compassionate, and he wants her home. That's the mom. That's who stays home and takes care of the kids, and the whole family's aching through this. So I think everyone will be made whole if she could just go back home, and mom could be mom, and you know, dad could do his thing, and you know, the family could just be together again.
All right, Ms. Brucker, any thought, any allocution that you have?
Judge, under the circumstances, given that there's not past history of domestic violence between them and the, you know, situation that brought this to the court's attention, I don't oppose the court lifting the no contact order in this place. I don't often say that, but I think in this particular case, based on the victim's letter, I don't see, you know, safety concerns with that as well. I just ask that the court place her on probation. This is a 76948 case. So there would need to be a period of probation, and I'd ask probation perhaps to meet with her and determine whether any programming is appropriate. I don't think she needs a batterer's intervention program, but I don't know what the other, you know, factors are in the situation, and perhaps probation could just make a recommendation.
One more. As far as probation goes, I would just ask that it be a shorter term. Basically, like the prosecutor said, this is rather strange consequences or strange circumstances, and no one was injured. It was just shock and awe. And you know, I think most reasonable people would have been extremely upset at that situation. But again, he's, you know, 1'3" bigger than her, weighs over 100 pounds more than her. He was never in any kind of like actual danger. Granted, she should have never put her hands on him, and she knows that now, but he was never in any kind of danger to be actually harmed in any way. He's way, way bigger than her. But with that said, I think anyone at that moment would have been very emotionally heightened and would have put, you know, shoving, smacking a little bit. But they've been together for 12 years, Judge. They're a happy family. They have children together. He wants her home. And in his victim impact statement, he said, "I'm not a victim, Judge." So I'm looking hopefully for like 3-4 months of probation.
All right. Ms. Campbell, you also have the right to address the court to give you any information to me that you want prior to sentencing. You're not required to do that. However, if you wish to, this is your opportunity. So go ahead, ma'am.
I think everything was said that needs to be said from my attorney. I just really want to go home. That's really all. Like, I just want my family together, and it was a horrible night. And honestly, the person that the third party person, she's out of my life. So I think that's the best that I can do, because I don't need toxic people in my life.
That's a true statement. However, there's lots of toxic people out there.
I agree.
It's hard to stay away from them sometimes. So how do I have any assurance that something like this is not going to happen again?
Because the person that it happened with is out of my life. She's not going to be around.
What are you going to do when the next one comes along?
That's not going to happen.
I hope that's true. In my experience, it's not.
Hmm.
There's going to be somebody else that gets under your skin. There's going to be somebody else that points out the negative. There's going to be somebody else that gets you to do something that you probably shouldn't be doing. We are social people, and we get in with the wrong group, or we get in with the wrong person, and they lead us astray. And that happens time after time after time until we as individuals realize, hey, I've got to do something different. I have to take responsibility for myself. And even though that person's toxic, I have to have skills and tools and abilities to stay away, or to drown them out, or to kick them out before somebody else has to make them move away from me. Do you understand what I'm saying?
I do.
All right. So that I'm going to give the probation officer discretion to recommend a treatment program for you if they believe that you don't have those skills and abilities. I think that's a good idea. It may be a good idea for you to search out a counselor to say, all right, is there some skill, or is there some way of looking at things that I can change in my own way to make this less likely to happen in the future? I'm not going to require you to go to counseling, but I think that would be a great idea for you, just to as a preventative action in the future. So I am going to put you on probation for 6 months. We have a policy here at this court that after 3 months, you can ask for permission to be let off early if you've taken care of all of the other things that you're supposed to do. Because this is under 769.4A, and once you're off probation, if you successfully completed it, you would not have a criminal record because of this. If you don't do things successfully, however, then you would have a criminal record. Do you understand all of that?
I do, Your Honor.
All right. The 6 months of
I'm so
the 6
sorry.
months.
With it being a domestic violence charge, she cannot get off at halfway.
All right. Thank you for letting me know that. Then I am going to put you on for only 3 months, 90 days. Okay. That's going to cost you $90 in oversight fees. There's a $75 crime victim fee, a $50 judgment assessment. There's a $150 court costs, $15 local charge, and a $75 fine. You can pay that over the course of your probation. I'm going to give you the ability to perform community service if you can't make the fines and costs payments all on your own. I am going to require you to enroll and successfully complete a treatment or education program at the discretion of the probation department. While you're on probation, no consumption or possession of alcohol or drugs, no entrance to a business where alcohol is served by the glass. That means you can go into a restaurant that serves alcohol, but you cannot go into a bar that happens to serve food. Do you understand that?
I do.
All right. Drug and alcohol testing as a part of your probation at the discretion of probation. Again, it may not be a big deal for you, but in my estimation, most of the cases that come in front of me have one of those issues going on. I want to make sure that you don't run afoul of that. I am going to take off the no contact, but you're still on probation. So if there is some problem in the next 3 months while you're on probation, it falls on you. Whether you're the cause of the problem or not, you're the one that's at risk. So I want you to go into this with eyes wide open. If you're going to go back in and be a part of this family, and that's a good thing to be a part of a family, but you and your behavior has to be spotless. And if there is a problem, you're the one who has to walk away, not anybody else. You understand?
I understand.
All right. While you're on probation, there's no assaultive, abusive, intimidating, or threatening behavior. I'm not going to require any jail time, and I'm not going to require you to go to work camp. Those are all the conditions that you'll have to abide by. Any questions about that?
No, thank you, Your Honor.
You're welcome. Counsel, any questions?
We're all set, Judge. Thank you so much.
Ms. Bruker, anything?
No questions.
All right, that'll be the order of the court. Thank you.
Thank you.
I've received two things from you. One is a motion to compel discovery and or dismiss for lack of probable cause. The other is a motion to withdraw. Which one would you like to do first, and how do you want to proceed today?
Let's do the motion to compel with motion to dismiss first if possible, Judge. I do have one witness to call on that.
All right, Ms. Bruker, have you filed a response to that motion?
I did.
I thought I read it. Motion the 22nd.
Thank you, Judge.
Next case is the state of Michigan versus Philip Keck. That's file 25-43388-SM.
Thank you, Your Honor. Jonathan Baber on behalf of Mr. Keck.
Hi, Your Honor, I'm here as well.
All right, I do see Mr. Keck is with us as well. Ms. Bruker is here. Mr. Baber, I've received two things from you. One is a motion to compel discovery and or dismiss for lack of probable cause. The other is a motion to withdraw. Which one would you like to do first, and how do you want to proceed today?
Let's do the motion to compel with motion to dismiss first if possible, Judge. I do have one witness to call on that.
All right, Ms. Bruker, have you filed a response to that motion?
I did.
I thought I read it, and I don't see it in my court file at the moment. Let me make sure I didn't misplace it someplace. I cannot find it at the moment, Ms. Bruker. Do you have it right there with you that you could email it to the courtroom and have, can we print it out here or not?
Yes. Yeah.
Could you email it to me, Ms. Bruker?
Yes.
I know I've seen it. I'm positive I've seen it, but I just don't have it with me.
Yes, just give me a minute and I'll email that to him. Judge, and I did just want to say, as far as potential witnesses, the only witness I could think of would possibly be Deputy Dean. He explained to me yesterday that he and one other deputy are the only ones on today in the county, and that if he was called out on something, he would not be able to be here. And I don't see him here right now, so I don't know how this is going to go, if the court's going to be prepared to rule without testimony or not, but I just wanted to indicate that.
I appreciate that. Thank you very much. Mr. Baber, who is it that you want to be calling as a witness?
Andrea Cerveni, she works with the Michigan Department of Health and Human Services. She's been subpoenaed. As I applied a copy of the subpoena to the prosecutor in this court. She is available via Zoom. Her testimony is going to be rather brief. It's impeachment only testimony.
That is the statement in her report that you referred to about what the original deputy said.
That's correct.
Ms. Bruker, did you have a copy of that report that she submitted, Ms. Cerveni?
I did. Mr. Baber submitted a number of exhibits. I did see her report.
All right, Mr. Baber, is she going to testify consistent with what is in her report?
And Judge, that report is not drafted by Ms. Cerveni. That report just reflects Ms. Cerveni's statements. She was the one who took the phone call from Deputy Dean on that particular day. She made notes of her conversation, and those notes ended up making it into that report. So that's just a brief bit of testimony that I need from her. I think I have a total of 16 questions to get us there.
Is there anything that you need that's not in your arguments already? I'm just trying to save a little bit of time. I'm not saying that I'm basically saying I'm not going to dispute what you're telling me she's going to say.
Basically, she's going to say what was drafted in my motion, Judge.
All right. Ms. Bruker, do you have any objection to me taking what's in his documentation as an offer of proof?
No, Judge.
All right, Mr. Baber, if I do that, do we need to have Ms. Cerveni testify today?
No, Judge. With that, I would ask this court to excuse Ms. Cerveni from her subpoena and allow her to log off.
All right, ma'am, you are free to go. Thank you very much for being here. Appreciate your time.
Thank you.
All right, Mr. Baber, thank you very much for assisting me with that. Give me just a minute to make sure I've remember what was in Ms. Bruker's brief, and then I believe I would be ready to hear your arguments.
Thank you, Judge.
All right, it is what I thought I remembered. Mr. Baber, go ahead with your argument.
Thank you, Your Honor. I'm going to take it chunk by chunk and try to be as brief as possible, beginning with the equal protection argument in regard to this case. Now, I don't make this argument lightly, but if you look at it from the perspective of Philip Keck, it raises questions about whether or not he's being treated differently than other individuals in a similar situation. If you look at Mr. Keck, he filed a claim stating that he was a victim of domestic violence, and the prosecution says, we're not going to prosecute. He did it again in this instant case where he was the victim of domestic violence and had to use self-defense. And again, the prosecution declined to treat him as a victim. Followed up a third time where his wife, Alyssa, fraudulently used his name and signed checks from a business account she's not associated with, and signing the checks to herself personally. He is a victim there. And again, the prosecution denies him access to justice. Instead, they favor Alyssa Keck. And it makes us question, what is the primary difference between Mr. Keck and Mrs. Keck? And the only difference that is on paper is that Mrs. Keck is a female and Mr. Keck is a male. So there's a slight bias here because the prosecution hasn't provided us with any other reason for declining to treat Mr. Keck as a victim other than stating they have broad discretion about what charges they wish to bring. Now, that may be so, but there's a limit to that power and a limit to that discretion, and a prosecutor cannot be making charging decisions based upon gender and preferring one gender over another and protecting females over males, which appears to be the case here. Mr. Keck is just looking either for an explanation or equal access to justice. In this situation, the prosecuting office should have, especially on the forged check case, recused itself and sought an outside prosecution through the Attorney General's office, as they routinely do when there's a conflict. And in this case, they decided not to do that, probably because it could be evidence used against the victim in this case for forging checks, because it's a crime of dishonesty. So ultimately, they are limiting my client even in raising his own defense by refusing to even submit this out for another prosecution to take a look at it. I'll move on to the probable cause in this case, Judge. Again, this is a situation where it is a he said, she said situation. Both have injuries consistent with their testimony. Why they decided to charge Mr. Keck and not Mrs. Keck is beyond me. There's no evidence leaning one way or the other to support that Mr. Keck was the actual aggressor in the situation. And if you look at what Deputy Dean had stated to the Department of Health and Human Services, even he said, hey, the timeline's confusing. I personally do not know who the aggressor was in this particular case. So Deputy Dean himself, by his own admission to Michigan Department of Health and Human Services, didn't have probable cause to arrest or charge Mr. Keck in this case. And without that probable cause, the case should be dismissed. Moving on to the motion to compel side of this, Judge, I'm not asking for all police reports concerning Alyssa, Mrs. Keck. I'm just asking for the police reports and the body camera concerning Mrs. Keck and Philip Keck. This is a long history between the two of them having verbal disagreements over how their children should be raised and who should be in their children's lives. And ultimately, the police contact has been numerous between the two of them concerning that particular issue. That issue was at case in this particular situation, and therefore it's relevant to the history in this case and may eventually become an issue at trial. I'm not saying that the stuff I'm requesting is going to be absolutely admissible at trial, but this is just the discovery phase. We should be entitled to it, and then we can make arguments later in motions in limine whether or not it's going to be admissible. Further, excuse me, Judge, there is one particular police report where a third-party witness in this case underwent a psychological evaluation, and it was determined that this witness could not tell the difference between a truth and a lie. That's very relevant when this witness may be called for a jury to hear, hey, this is what this person said, but this person also, clinically speaking, does not know the difference between the truth and the lie. So all of the things that we are requesting, I believe, are relevant to this case at this point in time. And we'd be requesting that those be turned over to us unredacted, along with the video containing statements of all the witnesses in this case, Judge. Thank you.
All right. Ms. Bruker, any response?
I'll be quick, Judge. As to the equal protection argument, essentially, Mr. Baber is alleging because there are warrants that may have been denied that his client has been discriminated upon because he's a male. Mr. Baber used to be a prosecutor. I know Your Honor used to be a prosecutor. We deny warrants for many reasons. And he's not made, he's not made the argument, the link between Mr. Keck being a male and these warrants being denied. As to the affidavit, the information required in an affidavit of probable cause is some evidence on each and every element of the crime, so that the magistrate or judge reviewing it can determine that there is probable cause that the crime was committed, and that is there in the face of the affidavit. Questions about who said what, about whether or not who the aggressor was, are going to be questions of fact for the jury or the fact finder. As to the reports, I still don't think Mr. Baber is given a causal connection for why reports from 2022 would be relevant in this particular case, and body cam footage from all of these reports. When you look at these, some of these are civil disputes where police came out, didn't take any action. Some of them are other kinds of complaints. I'm not sure if any of these came through to our office to be reviewed, except maybe one of them. And I don't know whether or not, I'm not sure what the retention policy is on body cam, whether that's available. So I would ask for the court to deny that as well.
All right, thank you both very much. Just for the record, I want to state that I did review all of the documentation that was submitted by Mr. Baber on the CD, including his motion to dismiss and all of the exhibits that went with it. So I've thoroughly reviewed all of that information prior to today's hearing. So let me start with the previous complaints, because I think that helps me explain why I'm going to do what I'm going to do in the other two equal protection and probable cause decisions. As to Mr. Baber on page 5 and 6 and part of page 7 goes through each of the documents that he submitted and that I reviewed. So let me comment on each of those. It's going to take me just a minute to do so, but I think it's will help with the understanding of where I'm going with this. So on page 5, the first bullet point says that there was an August 28, 2022, Michigan State Police responded to a quote false complaint where she alleged that the defendant pushed her. I reviewed that document. It's Exhibit F, and I do not find that to be a false complaint. There was physical contact noted in the complaint. The defendant's arm, and the finding was that it did not rise to the level of domestic violence, but it did not indicate that there was a false allegation. Therefore, I don't believe that that document is relevant, as it doesn't show a false complaint or a false allegation. The next document, August 28th, Alyssa requested assistance for a civil standby so she could retrieve belongings. Again, it's not a false allegation. There's no evidence of bias or prejudice by the police or anyone else in that document. So I don't make any finding as to that as well. The third one is on September 18th, 2023, the police, Michigan State Police responded to a domestic where the defendant was the victim of domestic violence. That is an allegation that Mr. Keck has made. It is not what was found within the document. Within the document, it's found that the kids could have confirmed whether he was the victim or whether she was the victim. And Mr. Keck did not want the police to interview the children, so that the report then was unsubstantiated and no action was taken. So it's not, again, not a false allegation, no evidence of bias, but this was a decision that Mr. Keck made to not have the children interviewed, who could have very easily confirmed which of the two parties was at fault. The next document is September 29th of 2023. The police, Michigan State Police assisted the Sheriff's Department in a welfare check of the children. Again, not a false allegation, not an indication of domestic violence, and no use as an equal protection argument, no use as a discovery argument, no use as a probable cause argument. On October the 1st of 2023, the next document was a defendant requested assistance in locating Alyssa and the children. Again, this is not an allegation of domestic violence. It's not an allegation of false complaints. And it was during the divorce process, and it appears that the defendant is using the police to assist him in his custody and parenting time arrangements or arguments. The next document is from October 6th of 2023, where the Sheboygan County Sheriff's Office notified the Otsego County Sheriff's Office that they had located and arrested Alyssa. And then they transported her to the Otsego County Jail where she was lodged. Again, there's no issue of domestic violence here. There's no issue of a false complaint or false allegations. There's no evidence of any police bias or prejudice. It's simply a statement of fact. And so I don't believe it has any relevance to an equal protection argument, probable cause, or discovery. The next document is from November the 22nd of 2023. The defendant contacted the Otsego County Sheriff's Department to report a parental kidnapping. This, in essence, is a custody dispute. It's Alyssa is alleged within that document to have returned to the house later the day, and there's no false allegations on her part. This is again the defendant reporting this as a parental kidnapping, attempting to use the police in his custody and parenting time dispute with Alyssa, but it does not appear to be any false allegations on behalf of the police or any false allegations from Alyssa, and it appears that the defendant is using the criminal justice system, not the alleged victim in this complaint. The next document is on December 28th of 2023. Defendant contacted the state police to do a wellness check on Alyssa. And the police found Alyssa and subsequently found a pistol on her front lawn. Again, there's no documentation or evidence that Alyssa made any false statements. There's no evidence of any bias by the police or by the prosecution, and there's no impeachment evidence available in that document that I was aware of or that I saw. And so I don't believe that it is relevant either. January 19th of 2024 is the next document. The Michigan State Police responded to a dispute between the defendant and Alyssa. The police arrived to find Alyssa locked defendant out of the house and would not let him in. Again, the parties are now divorced, I believe, at this point. There's no allegations of any false statements by Alyssa, any allegations of domestic violence, and there's no indication of any impeachment evidence available from this document. Again, so it does not go to an equal protection argument, does not go to probable cause, does not go to any discovery that I'm aware of. The next document is on February the 5th of 2025. The Otsego County Sheriff's Department investigated Alyssa for fraudulently signing his name to checks drawn on the defendant's business account. This is an allegation talking about he said, she said. This is exactly what the defense has railed against, saying it's he said, she said. This is that. He's making a claim that she falsely wrote her name on a check and his business account. When interviewed, she told the Sheriff's Department that she had the ability and had in the past done that. They told her that this was a civil matter, and that's where it was left, and that's where it went. Given my experience as a prosecutor and as a defense attorney for the last 38 years, that's a normal occurrence. Probably 50 or 100 times every year as a prosecutor and a defense attorney, you see something like that. This again appears to be the defendant trying to use the criminal justice system to aid in his divorce, custody, or parenting time process, as opposed to anything otherwise. I'll come back to that in just a minute, but that's where I'm going to leave that for the moment. The next document is on February 7th of 2025. The Michigan State Police responded to a welfare check of the children filed by the defendant. Once again, the defendant is using the criminal justice system to assist him in his custody parenting time dispute. There's no evidence of false allegations. There's no evidence of bias or prejudice. And so those irrelevant information. The next one is from the same date, February the 7th of 2025, where Alyssa contacted the Otsego County Sheriff's Department alleging the defendant came into the home and took all his firearms. Again, this is not a false report. She indicated that the firearms were missing. Found out later that the defendant had previously moved them by someone else. He didn't tell her that the firearms were removed from the home that she was in. She reported that the firearms were missing. There's no false allegations, no allegations of bias or prejudice by the police. And again, I see no impeachment value or bias or prejudice or equal protection argument from that. The next document is from February the 8th of 2025. The Sheriff's Department served Charlevoix County PPO on the defendant and asked the defendant about his firearms. This is similar to the above, the February 7th finding that I just made. Again, there's no indications of falseness, bias, or prejudice, no indications that could be used to impeach anybody, and it's therefore irrelevant information. The next document is from February the 19th of 2025. The Michigan State Police conducted a forensic interview of the child, KSK, and where they indicated that young child struggled with telling the difference between a truth and a lie. Whether or not that continues to be the same thing, competency and knowledge of the ability to tell a truth or a lie is a day-to-day, sometimes thing that happens especially for a child over time. So there may be a change from when it happened then to where it is now. However, there's no information in the probable cause affidavit that the information in the probable cause affidavit came from KSK. The only indication is that that child was present, but there's no evidence of what the child said or saw within the probable cause affidavit. So whether or not KSK can or can't tell the difference between a truth and a lie, it makes no difference in whether or not there's sufficient probable cause within the document. Within the probable cause document. The next document put forward is February 26th of 2025, where the defendant contacted the Michigan State Police to report Alyssa for check forgery. This is after he'd already had that same investigation request denied when it went, I believe, to the Sheriff's Department. And so once again, he is attempting to continue to use the criminal justice system to force his way and his view of how things should be done when it's already been denied once in the past. And it was, so I find no bias or prejudice there when the state police took no action, when the Sheriff's Department had previously investigated it and took no action. The last document that it's alleged is on February the 27th of 2025. The Sheriff's Department were called for a civil standby for the defendant's mother retrieved his personal items from the home. And Alyssa refused, apparently, or alleged to refuse to hand over a trailer hitch and refused to answer why she needed the hitch and refused to turn over a pair of cowboy boots. There's no indication that any of that is false. There's no indication that that is domestic violence, and there's really no impeachment evidence there. It's not surprising to this court that divorced parties don't get along. But that doesn't mean that there's any impeachment or bias or prejudice information that's there or that would be appropriate for a criminal trial. At best, it's impeachment and it's information that the defendant already has through the witness of his mother. All right, as to the equal protection argument, I find no equal protection facts in this case. The defense can certainly say, well, I'm a guy, she's a girl. The prosecution hasn't accepted my side of the story. We are far from being able to call that proven. The story fits just as equally to say the assessment of credibility is that they don't believe the defendant and they believe her. That's just as rational an argument as the argument that says, well, it's he said, she said, and because they're siding with her, it must be because I'm a male. That's a conclusion without a factual basis on these facts as I find them today. As to the probable cause determination, I find within the affidavit of probable cause a statement from Alyssa when she called 911 stating that she was assaulted by, and she indicated who it was, Philip Stephen Keck. That does support the charge offense. Further in that probable cause affidavit is Alyssa stating that Philip, the defendant in this case, began screaming in her face. She was afraid that Philip was going to hit her. She recalls Philip picking her up off the couch and throwing her on the rug. Alyssa did show a fairly large rug burn on the left forearm. All of that supports probable cause. The defense argues, well, lots of other things were left out, as in all of the things that I just detailed on the record. None of which, the things that were left out, none of which, in my mind, rise to the level of taking away probable cause. In addition, the defense never argues about the physical evidence that's noted in the affidavit, which is the fairly large rug burn on the left forearm of Alyssa. In essence, they left it out, which is what they're arguing that the prosecution did. They left out certain information. Well, the defense did the exact same thing. It left out any argument, any statement of fact about the victim, Alyssa, had physical evidence on her that corroborated the story that she told to the police. Secondly, so I don't find a proper factual basis within the arguments in this case for a lack of probable cause. Next, as to a legal basis for this, where there is the defense is entitled to, constitutionally, they're entitled to challenge the veracity of the warrant affidavit. That's under the case of Franks versus Delaware, 438 U.S. 154 from 1978, and which is upheld in Michigan under the Supreme Court case of People versus Franklin, 500 Mich 92 from 2017. The defendant is only entitled to an evidentiary hearing, however, on that, where the defendant makes a substantial preliminary showing of a deliberate falsehood or reckless disregard for the truth by the affiant. There is a presumption of validity with respect to the affidavit supporting the search warrant, and the attack must be more than conclusory and be supported by more than a mere desire to cross-examine. There must be allegations of deliberate falsehood or of reckless disregard for the truth. None of the allegations in this case rise to that level. The allegations of negligence or of mistake are insufficient. It's only when those requirements, that of deliberate falsehoods or reckless disregard, if met, that is when there would be a requirement of a hearing, and then there would have to be a preponderance of the evidence, a probable cause determination that those allegations are true. I don't find in this case that there's even proof requiring a hearing. I don't find any allegations of deliberate falsehood or reckless disregard, because all of the allegations of falsehoods, in my view of the evidence, ring untrue. There's no falsehoods involved. There are he said, she said statements, but there's no indication of that the police knew that any of those things were false at any time. Even having said all of that, even if you would believe that some of those statements were false, if you put the remedy for that is you put all of those statements together, you put all that information into the affidavit of probable cause, and then you determine, is there still left probable cause? And that's the remedy that's listed in Franks versus Delaware and in the Michigan Supreme Court case of People versus Franklin. And quite frankly, after I did that, I'm still left with the allegations of Alyssa, which were corroborated by the physical evidence at the scene of the bruise or the large rug burn on her left forearm, which is consistent with how she said the evidence occurred. A probable cause is a very low standard of proof. It's less than a preponderance of the evidence. It is more than a reasonable suspicion, but it is a probability, not just it's not a reasonable belief. It's not anything greater than that. It doesn't, in fact, you can be wrong more often than not and still have probable cause. So for all of those reasons, I'm going to deny all of the arguments. I don't believe that there's any relevant or improper discovery that would be, proper discovery that would be obtained. I don't believe that there's any equal protection violation. I don't believe that there's any probable cause violation. And so the motions, all three motions are denied. Mr. Baber, you still have your motion to withdraw. Do you still wish to do that today?
Yes, Judge.
I have read all of that. I'm not going to require you to put all of that on the record unless you want to. Is there anything else that you want to say?
Yes, Judge, just not in regard to the motion, but how it came about. Ultimately, I tried to resolve these issues without having to file motions in every one of my cases that I still have outstanding, which are 10. Unfortunately, I could not make that happen. They are still making me go through the motions of getting an order for this court before they will reassign these cases to attorneys that they have the room to take these cases up, as was indicated in an exhibit attached to my motion. So I apologize for taking up the court's time, but I was left
Nope.
with no other choice.
I don't have any problem at all with the way that you've done this, and I appreciate you, the upfrontness that you've given to me in providing me with this information. Ms. Brucker, do you have any objection to his motion to withdraw?
No, Judge.
All right, I will grant that motion. Mr. Baber, I don't remember seeing a proposed order. Did you submit one to me?
I have not, Judge. It's kind of my first case. It's my test case. I want to see this court's temperature on it. So I will draft an order granting the motion to withdraw. I'll also supply the court with that in order denying the motions in the previous motion for this
Thank you.
court.
Do you want to, well, I'm just trying to think whether or not we should, for any other case that you have, do you want to do something under a 7-day notice for that? I mean, I'm inclined to grant your motion on just about every case, well, every case that you're on, unless there's some reason for immediate action is necessary for an attorney. But I don't know that would be, I mean, we can appoint a new attorney fairly quickly. So
What I think I could do, Judge, is we could leave it on and I'll have a conversation with Ms. Brucker. Maybe we can just agree on some language and she'll stipulate that she doesn't object to my motions, and we could supply an order to this court, and the court's freely able to keep them on the docket or sign the orders based upon what's in the motions.
I'm satisfied by that. I'll leave it to your judgment how you want to proceed on that, sir. So go ahead and send me a proposed order on this particular case, and then on the future cases as well. And I'll just go with what I see once you get here. Now that we have denied these motions, where do we need to go next?
Judge, I guess I'd suggest, since Mr. Keck's going to be getting a new attorney, maybe we just get a status conference so he can get up to speed with his new attorney, and then we'll go from there.
I think that's a great idea. Mr. Keck, do you intend to hire your own attorney, or do you still want to have court-appointed counsel?
Still would appreciate court appointed.
All right.
Once
Mr.
I get
Baber,
the
if you would.
once I get the order
agree-
back from the court, I can notify MDIC of the situation, and they are supposed to assign new counsel immediately. So
If maybe you would include just a line in that proposed order that requires them to appoint new counsel, I'd appreciate it.
okay, can do, Judge.
Thank you very much. And we will set this for, I'll set it 3 weeks out. I'll send notices out to, once we get the new counsel, I'll send notices out to that. Mr. Keck, if you would keep in contact, once you're advised of who the new attorney is, make sure you get a hold of that attorney, and so that you don't miss anything. We will send notices out to you. I have you on Old 27 North in Gaylord. Is that correct, Mr. Keck?
Yes, Your Honor.
All right, we'll send the notices there. If there's a mix-up of some kind, contact the court a few days in advance of the next court date. Make sure you've got an attorney, make sure that we're ready to go, all right?
You said 3 weeks out. You're just going to notify me of the day, not?
Correct. They'll send you a notice setting a hearing in approximately 3 weeks. That should give you time to meet with your new attorney. Hopefully we'll get the paperwork back and forth from Mr. Baber to the new attorney quickly. But I just want to make sure that you're not, the things aren't going too slowly. I want to make sure that your rights are protected that way. All right, sir?
All right, I appreciate that. Thank you.
All right, that's all for today then. Thank you.
Thank you, Judge.
State of Michigan versus Kaleb Smith.
Larry Brown on behalf of Kaleb Smith.
I do see Mr. Smith is present with us, as is Ms. Brucker from the prosecutor's office. This is set for a status conference. Do we have a resolution of this matter?
We do, Your Honor. I have had conversations with Mr. Smith as well as Ms. Brucker. There has been an offer in this matter to plead pursuant to the 7694A deferral. It is my understanding that is the way we are going to proceed today.
Is that accurate, Ms. Brucker?
Yes, Your Honor.
All right. Mr. Smith, you've heard what the attorneys have said. Is that what you want to do today?
Yes, sir.
It's my understanding that a plea, you would be pleading as charged to domestic violence, and in exchange for that plea, you would receive a process known as deferred sentence under 769.4A. That's a statute that says that if you successfully complete the probation that you're put on, that the case would be dismissed and you would not have a criminal record from that charge. Do you understand all of that?
Yes, Your Honor.
And is that what you want to do today?
Yes, Your Honor.
All right, I have some rights that I want to talk to you about and make sure that you understand them. Because if you enter a plea and take that agreement, you would be giving up your right to have a trial. And you would not have any of the trial rights that you currently have if you wanted to exercise them. At a trial, you'd have the right to have a trial by a judge or by a jury. You'd have the right to see, hear, and question the witnesses against you. You'd have the right to be represented by your attorney, and Mr. Brown would continue to represent you at that trial. You'd have the right to present witnesses, and you'd have the right to have an attorney and a subpoena to require those witnesses to appear and testify on your behalf. You'd also have the right to testify, or you could remain silent. And if you chose to remain silent, that silence could not be used against you because you have an absolute right against self-incrimination. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof beyond the prosecutor at all times. If you would have a trial, or if you wanted to have a trial, you'd also have the right to automatically appeal anything that you believed happened wrongly at that trial. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might be denied, and that would be the end of the matter. Do you understand all of those rights that you would have would be giving up at a trial?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, sir.
Knowing all of that, do you still want to proceed today with entering this plea?
Yes, Your Honor.
All right, I'm gonna need to take some testimony from you. Would you raise your right hand? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, put your hand down. Has anybody promised you anything other than what's been said in court today in order to get you to plead guilty?
No, sir.
Has anybody threatened you in any way in order to get you to plead?
No, sir.
Are you doing this of your own free choice and free will?
Yes, sir.
Have you had sufficient time to discuss all of this with your attorney, Mr. Dick?
Yes, sir.
All right. The charge against you from the prosecutor reads as follows. It says that you did on or about March the 17th of 2025 in Otsego Lake Township of Otsego County, that you did make an assault or an assault and battery upon Maria Hall, an individual with whom you had a dating relationship. Is that true?
Your Honor, I hate to interrupt. I think you said his attorney, Mr. Dick.
I did, and I apologize. It's Mr. Brown. The first attorney I saw was the name I said, so I apologize for that. So you understand that your attorney is Mr. Brown, and he would be the one assisting you at a trial if you wanted one, right?
Correct.
All right. So as to this charge that's been made against you that you now want to plead to, it says that you did an assault or an assault and battery upon Maria Hall, an individual with whom you had a dating relationship. Is that true?
Correct.
How do you know Maria Hall?
She still is my girlfriend, but she was the girlfriend at the time.
All right. And you had been dating her for a period of time prior to March the 17th of this year?
Yes, Your Honor.
And this says that you assaulted or did an assault and battery on her. What did you do that makes you believe that you assaulted or did an assault and battery to her?
We got into a scuffle, wrestled a little bit, and then it got proceeded where I called 911 because I was choked and
okay. What you just told me there is that we did certain things and I got choked, none of which is you assaulting her. If you're going to plead, you have to admit to me that you did something wrong. I can't have you saying, well, I didn't do anything wrong. It was her fault. You understand what I'm saying?
Yes, sir.
Okay. So if you need additional time to talk to Mr. Brown about this, we can do that. Or you're going to need to tell me some more facts about what you did to make her believe that you were going to hit her or hurt her or assault her or batter her.
In the beginning of the initial, when she was moving out, I was helping her pack her stuff into the back end of her vehicle. And I did grab a hold of her arm or her shoulder while she was grabbing her stuff. And that's when we got into the tobacco out front. Then I proceeded to help her load her stuff. After that, everything was kind of kosher. And then when we came inside, I asked the children to basically get out of my house. It got heated where I was like, get out of my house. And that's when Maria stepped in and punched me in the side of the face. And I asked her what that was for. And then I proceeded to say, basically, get out of my house. Please just get out of my house. Just leave. And that's when I was talking to the kids, yelling at the kids to get out of my house, all of them to get out of my house. And then that's when she grabbed me by the throat. And I walked out back and called 911.
Okay, Mr. Smith, you've now repeated to me all of the things that she did to you. The only thing that you've told me is what you did was you grabbed her by the shoulder, which doesn't sound to me like you did it. At least you didn't tell me that you did that in anger, or you did that to hurt her, or you did that to make her believe that you were going to continue to hurt her. So what you've basically told me is she did all the bad stuff. I was the victim, and I can't accept a plea from you that says, I'm admitting that I did something wrong. That's what a plea is. I'm admitting that I did something wrong. If you want to assert a defense, that's what a trial is for. So, Mr. Brown, I'm going to ask you to have some time and talk with your client. We're going to adjourn this matter for you to do that, because I don't want to take a plea from him on something that he doesn't believe that he did.
Yes, Your Honor.
All right. This is, let me see what the age of this case is. Looks like we were arraigned in March. Are you going to need any more time? Looks like my next court date would be, is it still the 28th that's open?
Yeah, 28.
All right. The next time that I have available is May the 28th. Would that be sufficient time for you to meet with Mr. Smith and
Yes, it
discuss
would,
with
Your-
him?
Yes, Your Honor.
All right, we'll do that then. Mr. Smith, you're going to get a notice in the mail from the court as to the exact time and the exact date. I don't set those things. The court staff does that to make sure that I have sufficient time to do all of this stuff. But we're going to send it to you at an address that we have for you on Sherwood Drive in Frederick. Is that accurate?
Yes, Your Honor.
All right. In the meantime, you're going to need to get a hold of Mr. Brown and discuss with him in detail what it is that actually happened, whether it's exactly what you said or not, and then what the legal requirements are, and whether or not you want to enter a plea or whether you want to go to trial. All of those things are things that Mr. Brown knows a lot about. He'll be able to advise you, but I want you to understand what the legal requirements are for each of the proceedings that you're going to be in next, okay?
Yes, sir.
All right. That's all for today then. Thank you very much.
Thank you, sir.
Thank you, Mr. Hall.
Good to see you.
All right, this is the state of Michigan versus Daniel Hall. This is date, time, and place set for a jury status conference. Do we have a resolution of this matter?
Judge, yes, we do. We have a plea agreement subject to your approval. It would be for a plea of guilty to domestic violence first offense, the 93-day misdemeanor, with no objection from the prosecutor's office for a DV deferral per statute.
That's correct, Your Honor.
All right, thank you. Mr. Hall, you've heard what the lawyers have said. Is that what you want to do?
Yes, Your Honor.
All right, as I understand it, you would plead as charged to domestic violence, in exchange for which you would receive what is known as a delay of sentence under the statute that allows that. And if you complete that delay of sentence period appropriately and properly, the case would then be dismissed and you would not have it on your record. Is that what your understanding of the agreement is?
Yes, Your Honor.
All right. Right now you have certain rights, and I want to talk to you about those and let you know what they are so that you can make an informed decision. If you have any questions, let me know, and I can either have a breakout room with your attorney or I can try to answer the questions. But these are your rights. You have the right to plead guilty, not guilty, or to stand mute. You have the right to have a trial by a judge or by a jury. You have the right to have an attorney like your attorney, Mr. Steffi, assist you at all portions of the case. If you wanted to have a trial, you'd have the right to see, hear, and question the witnesses. You'd have the right to have witnesses appear and testify on your behalf and get an order from the court called a subpoena to require them to appear and testify. You could be a witness, or you could remain silent. And if you chose to remain silent, that silence could not be used against you because you have an absolute right against self-incrimination. You also have the right at a trial to be presumed innocent until proven guilty beyond a reasonable doubt and have that burden of proof be on the prosecutor at all times. Also at a trial, if you think something is wrong or doesn't happen the way that you think it is correct, you'd have the right to have an automatic appeal. However, if you enter a plea, you'd only have the right to ask for permission to appeal, and the court could say no, and that would be the end of it. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that if you plead today, all of those rights other than your right to an attorney would be waived or would be given up?
Yes, Your Honor.
Knowing all of that, do you still wish to enter a plea today?
Yes, Your Honor.
All right, let me ask you to raise your right hand so I can swear you in and take some testimony. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, go ahead and put your hand down. Has anybody promised you anything other than this plea agreement to get you to enter this plea today?
No, Your Honor.
Has anybody threatened you in any way in order to get you to plead today?
No, Your Honor.
Are you doing this of your own free choice and free will?
Yes, Your Honor.
All right, the complaint filed by the prosecutor against you says that on or about March the 8th in 2025 in the city of Gaylord in Otsego County, that you did make an assault or an assault and battery upon Tamara Marie Deering, an individual with whom you had a dating relationship. Is that true?
Yes, Your Honor.
What did you do to make an assault or assault and battery upon Tamara?
I shoved her into a door frame, Your Honor.
Okay, and you are not claiming self-defense because as a result of that?
Two wrongs don't make a right. She grabbed my glass from my hand, threw it at me. I overreacted, shoved her into a door panel, Your Honor.
All right. And at the time that that occurred, you and Tamara were dating each other?
Yes, Your Honor.
How long had you been doing that?
3 years and 2.5 months, Your Honor.
All right. Do either of the attorneys have any questions as to the factual basis?
No, Your Honor.
I don't, Judge. Thanks.
Do you believe that I've complied with the court rule?
I
Yes,
do.
Your Honor.
Are either of you aware of any promises, threats, or inducements not placed on the record?
No, Your Honor.
I am not.
All right. I will accept the plea. I do believe it was given knowingly, intelligently, and voluntarily. The testimony meets the requirements for domestic assault, indicating that there was pushing and shoving upon a person with whom he had a dating relationship and the date, time, and place in the complaint. So I will accept that plea, and we will set this for sentencing. Ms. Brucker, do you wish to have the victim make an impact statement and then do the 769.4A at that next court hearing?
She sent us a statement yesterday that specifically only addressed the no contact order. So I'm gonna ask Ms. Weber, do you believe that she wanted to make any other statement aside from that?
Don't.
You don't think she wanted to speak at sentencing aside from just what she sent us?
Yeah.
Okay. So if the court wishes to go forward today, I wouldn't have any objections.
I don't have a copy of that document that you're referencing.
I'm trying to print it.
My staff here tells me that we do, and he's trying to get it printed right now. So, Mr. Steffi, do you want to proceed to sentencing today?
Yes, I would, Judge. Thank you. And I'd also like to address the no contact order whenever that's convenient. Thanks.
All right, let me see if we can get a copy of this to print out. That way I can review it and we can move forward.
Thank you.
All right, I've had an opportunity to read the letter that was looks like an email to Ms. Brucker from Tamara Deering, dated May the 14th, 2025. It is approximately a page in length. Was well written, does request that the no contact order be lifted for lots of different reasons that are indicated in the document itself. Having heard that, Mr. Steffi, I'm going to give you an opportunity in just a minute to both allocute for the sentence and to talk about the no contact order, but I'm going to hear from Ms. Brucker first. Ms. Brucker, your comments on sentencing and the no contact order.
Just briefly, Your Honor, what I would note for the court is that the situation was reported by a third party, a friend of Ms. Deering's. Ms. Deering had confided some information in her, and that individuals who reported this. There are some indicators in the report that came through this third party that seem to imply that this was not the first time there's been violence between Mr. Hall and the victim, as far as Mr. Hall being the aggressor in the situation. I would ask that the court place him on probation. I'd ask that the court order that he participate in the batterers intervention program. As to the no contact order, I have some concerns with the court lifting it if Mr. Hall's not participated in any programming prior to that, just given that there appears that there may be some unreported past history of domestic violence between he and the victim in this case.
All right, Mr. Steffi, your allocution.
Thank you, Your Honor. I know that Mr. Hall and the victim Tamara in this case have been dating for 3+ years. I believe, as represented to me by Tamara, that from her, there has not been a history of any violence. The third party's representation to that should be taken for what it is. I think the people involved in the relationship would know best. My client does not have any criminal history. He has a job. The physical contact in this case was a two-handed shove to the back, which did result in the victim striking the door frame. I don't think it was his intention to have her strike it, but he certainly pushed her in a disproportionate level of aggression to what had happened prior to that. So I think he's a great candidate for DV deferral. I don't believe any jail is appropriate, and I'd ask you to sentence him as such and remove the no contact order. Thank you.
All right. Mr. Hall, you also have the right to tell me what it is that you think I should know prior to me imposing any sentence. That's not something that you are required to do, but you certainly have that ability. And I'm happy to listen to anything that you want to say now if you wish to.
The prior history is involved CPS, and she divulged that information to the third party, Miss Eastham. And all those cases have been closed. There have been over 5 cases. And that's kind of been the reason that me and Tamara's life has been super stressed out, because her ex-husband is proceeding to use the state as a weapon and CPS as a weapon against us in our home, because they do not have the money to take us to court. It has resulted in CPS coming in our home over 5 times and closing every single case and allegation against us, me, her, everyone in the home alike. As for the event, no, I did not intend for Tamara to be shoved and hit a door frame. Yes, my overreaction is an overreaction. Honestly, I just want to go home. And I'm remorseful about what I've done.
All right. Anything else that you want to say, sir?
No, sir.
Ms. Bruker, remind me how long the batterers program is.
Now you're quizzing me. I know we usually have to, I want to say it's 9 months long. Because I know in the past when we put people on probation for 6 months, we're told that's not long enough.
The batter's program, sorry, the batter's program is 9 months.
All right. Thank you, Ms. Hill. All right, Mr. Hall, here's what I'm going to do. I am going to put you on probation for, it's going to be a sentence under the statute for domestic violence, MCL 769.4A, so that you do have the benefit of, if you successfully complete the probation, the case would be dismissed against you. But I am going to put you on probation for 9 months. I'm going to minimize the fines and costs. There's a mandatory crime victim fee of $75, a justice assessment of $50. I'm only going to charge you $100 in court costs and a $50 fine and a $15 local fee, and you can pay that over the course of your probation.
Yes, Your Honor.
In addition to that, you can do community service work if you can't make the payments. I am going to require you to take and enroll in the men's batterers program.
Yes, Your Honor.
I want you to gain some insight into that. In addition, as to the no contact order, I'm going to keep it in place with this proviso. If you and or the victim in this case have a counselor send me a letter recommending that you have contact with each other, I will lift the no contact provision. However, having said that, it puts you as a probationer in a very tricky position, because if there is, well, you would at that point be able to go home.
Yeah, but
once the counselor says you can, but you're the one that's on probation.
Yes.
So if anything happens in the home, you're the one who gets in trouble. You're the one who's subject to my reach and putting you in jail, revoking this delay of sentence, giving you a criminal record. All of those bad things that could happen are on your head, not anybody else's. It's easier if there's no contact, because then you don't have that balancing of what happens at the house. You're not in the house. You don't have to worry about it. This puts you at risk. Is that what you want me to do?
I see what you're saying, because it all does fall on my head, and I am in your reach. And you are giving me a great chance here with a deferral sentence. I mean, counseling would be good for, I think, the whole family, given the CPS situation and everything else. And I don't know, but I know she was talking about getting the girls into counseling because of all the CPS and allegations. But now they're kind of afraid to talk to counselors as of when I was still in the home, because you know, the police kept dragging them out of their classes and dragging them out of their home. And I mean, at one point that cops knocked on our door when tried to have her parents come doing a wellness check, and her kids get kidnapped by her fucking parents. So sorry, by her parents, Your Honor.
All right, sir, I can't solve all the problems in the world.
No, but I would be willing to do the counseling. And
all right, I put it as a part of this court order that the no contact order may be lifted upon recommendation of a counselor and a letter to the probation department. So if you want to pursue that, you can do that. If you don't want to pursue it, that's up to you.
How would we do that? Would me and her?
You would contact a counselor, and you would go and I'm assuming the counselor may also want to have contact with with the victim, Ms. Deering. However, that's up to the counselor. So once a counselor writes me a letter and says, I think it's appropriate for you to have contact, I'll lift the no contact provision. But you're going to have something in writing to the probation department that I can read and make that order. So until then, the no contact order stays in place, and you still have to go to the men's batterers group in addition to all of that. Now, if you don't want to do that, you just don't go to a counselor, and the no contact order stays in place for the length of probation.
Would you guys have a list of counselors that would be recommended for this matter?
I do not.
Okay.
You can, if you wish, you can maybe talk to your probation officer. They might have some people that are available. Your attorney may be able to assist you with that list as well. So there are resources out there for you. In addition to all of that, while you're on probation, there's no consumption or possession of alcohol or drugs, no entrance into a business where alcohol is served by the glass. That means you can't go into a bar. You can go into a restaurant that serves alcohol, but you can't go into a bar that happens to serve food. Do you understand the difference?
Yep.
You'd be subject to drug and alcohol testing at the discretion of the probation department. I'm not going to put you in jail, and I'm not going to require any work camp because you're on a delay of sentence, and I believe that would be all that was appropriate. Also, no assaultive, intimidating, abusive, or threatening behavior. And I'm going to keep in place the no contact provision with Tamara Deering until you've completed the no contact order recommendation from the counselor.
Could I ask why I would need to be drug tested if there was no drugs involved in the incident? I mean, I don't care about blowing in a tube every single morning if that'd be the necessary, but no drugs were involved in this incident. I feel like drug testing would be unnecessary.
Here's what happens in my world, sir. 90% of what I see, I'm not saying anything specific about you, but 90% of what I see is drug and alcohol connected. So what I'm trying to get you to do is to stay on the straight and narrow. And if it's not a problem for you, then the probation department probably isn't going to do a whole lot with it or about it in your particular case. But I'm just playing the percentages, saying 90% of the time it is a problem. So I'm going to impose it in this case. If you don't have a problem with it, it's going to be random. It's not going to be every day. It's going to be something that you're not going to have an issue with. All right, sir?
All right.
All right, that's all for today. Anything else, Ms. Brucker?
No, Your Honor.
Counsel, anything else?
No, Your Honor. Thank you.
All right, that's all for today. Thank you, sir.
Daniel, we'll
Thank
talk later, okay? Thanks.
Yes, sir.
Have a good day.
You too.